you have laws, Sharia law courts in England now? And if so, do you allow them to do the things that they're, like misogynistic things like murder their women when caught in adultery or scourge their wives? Do you allow that?
In other words, do the Sharia courts exist that can deal with the
Sharia
traditional
courts
criminal matters? Is not? But do not fear. No? What now? Go. Okay. You never give up the microphone.
No, okay. The first
I'll stand right here.
The first answer to your question is that everybody is bound by the law on murder, on assault, or whatever it is. So nobody can be exempted from the basic criminal law simply by claiming they're Muslim or they're subject to Sharia law or anything like that. So it's illegal to beat your wife, it's illegal to kill people, all these things apply to everybody. That's the first thing. The second thing is that we allow people to settle their disputes in Britain by agreement and sometimes by arbitration. Arbitration means that the two parties agree that somebody else will settle their dispute for them, and they agree that they will be bound in advance by the decision of the arbitrator. It's up to the two individuals to choose any arbitrator. It could be a Jewish court, a Bet Din, for example. It could be a Sharia court, in other words, an arbitrator who is applying principles of Islamic law. If those two individuals agree to be bound by a decision taking into account Islamic law, then, in principle, our courts will enforce that, at least in a commercial case. There is obviously concern that somebody may be coerced into agreeing to be bound by the decision of a Sharia judge, a Sharia council, a Sharia arbitrator, and that person is more likely, typically, to be the woman, the weaker party. So there is concern that Sharia courts are operating in a way that undermines the protection that our courts give, particularly in family cases, to women and others at a disadvantage.
I'm going to ask one quick question to Anne because she has to catch a flight back to Israel. And Anne, you'd mentioned this has been discussed, and I want to follow up on this. To what extent do the European governments, because I think this is important, fund these groups that are working with these NGOs? I mean, is money actually coming from European governments to move these lawfare matters forward? Then we'll go right back to the audience.
Thanks a lot. Yeah, actually the European Union and European governments are pouring in about more than tens of millions of euros a year to these organizations. The process is secretive. We've actually sued the EU under their Freedom of Information Act to try to get more information. Who's making the process, who's making these decisions, on what basis are they making these decisions. A lot of the groups they're funding are actually working against the policies that the European Union and European governments are trying to promote. For instance, they pour a lot of money into organizations promoting a one-state solution, even though official European policy is to support a two-state solution. And again, when we've raised these issues with European diplomats, they either don't know about it. A lot of times the money is transferred in local offices so that people back home don't know about it. In other cases, some local officials of European governments have been giving amounts of money that are right below the threshold that would need approval from the parliaments and legislatures at home. So it's a very serious problem. And one that we're working to try to find more information about. But in Israel, this is pretty much the only Western democratic country where we see tens of millions of dollars being pumped in annually funding opposition groups. And I consider that to be a breach of sovereignty and a impinging upon Israeli democracy. So.
Very good. Thanks. All right, next question. Let's go right over here, and then we'll come back with this.
It's on the Richard Joshua debate. I am a member of the bar and was consulted during the Almog debacle or scenario. Surely aren't we in the position in Britain at the moment, because we never fought Macover and Camlish through the courts in Almog in the way that Richard would have wanted us to? What is wrong with fighting with, there are enough Jewish lawyers out there, there are enough Israel sympathizing lawyers out there. Why can't we fight this matter through the courts once and for all, and to stop these ridiculous arrest warrants being granted by Pratt and his friends?
If Tzippi Livni had really wanted to make a name for herself, she would have come to London and got herself arrested. And that really would have provoked the British government to changing the law instantly and not waiting until after the election and putting it all off. I quite agree that it would have brought matters to a head and could well have been fought, but the Foreign Office, in all sorts of mysterious ways, seems to be briefing Claire Montgomery to come in and argue on behalf of either the British government or the Israeli government that these particular individuals have head of state, or not head of state, but immunity as members of a government. But I agree, it would be rather nice to fight these things in the court, as Richard says.
And Richard's done that.
Two quick things. First of all, Israel's policy as a nation state has been not to dignify the attacks upon her. So therefore, when they sought the advisory opinion from the International Court of Justice, what Israel did is file a 113-page affidavit that essentially attacked the jurisdiction of the court. The EU attacked the jurisdiction of the court. 30 countries attacked the jurisdiction of the court. But the court decided to accept jurisdiction, and no Israeli side of the case was then presented. When I filed what I believe is the only brief on behalf of a non-governmental organization standing up for Israel's inherent right to defend herself, I was shocked to learn from the clerk of court there were no others that addressed this issue. I think Israel was wrong, but Israel did the same thing with Goldstone. Somebody made the policy decision not to dignify it, and now we are reacting. The danger in being in a reactive stage is this, and I refer you to the July 9th, 2004 decision called Legal Consequences of the Construction of a Wall in the Occupied Palestinian Territories. And it indicates that the ICJ held that, and I quote, Israel cannot rely on the right of self-defense or on a state of necessity, end quote, to justify constructing the fence as a security measure. So the danger in not standing up is then you're stuck with something. Now, what are we stuck with? We're stuck with something that by definition is only an advisory opinion. But if you look at the International Court of Justice's own website, it makes it clear that advisory opinions, while not law, may be used for all purposes, and I'm paraphrasing just because of time, as if it were law, and then that has been done by taking the decision back to the General Assembly, getting more resolutions, and then being able to tout that 2004 decision as predicate for so many things down the road. Full stop with one anecdote. You know, when I say come forth and file actions, somebody ought to think about what kind of actions could be filed, what kind of actions should be filed. And I don't mean bad lawsuits with bad facts that make bad law. I'm talking about standing up against libel, standing up against slander, standing up against boycotts, standing up against accusations that are unfounded. In fact, let me ask a question, just simply to think about. If you're accused of apartheid, and apartheid is a criminal act, and you're in danger of criminal prosecution, but more than that, apartheid is seen as a terrible, racist offense, unacceptable in the world. If you are accused of that, if you as an individual were accused of that, would you not consider, especially since it wouldn't be true, would you not consider taking action